Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering diversity panic as woke-only federal contracts and loans get canceled. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Coming from the Washington Post, federal judge orders minority business agency open to all races. The ruling sides with white plaintiffs in finding the Minority Business Development Agency's presumption of disadvantage is unconstitutional. Also from the Washington Post, SBA program upended in wake of Supreme Court affirmative action ruling. A judge struck down a provision of a federal program meant to help minority-owned businesses only, a ruling that could imperil other programs that benefit underrepresented groups. From the Washington Post, federal judge orders Minority Business Agency open to all races. A federal judge in Texas has ordered a 55-year-old federal agency created to help minority-owned businesses to open its doors to all races, a ruling that potentially imperils dozens of government programs that also presume racial minorities are inherently disadvantaged, which they are not. It's time for us to all work together and treat everyone equally. In a 93-page opinion rendered on Tuesday, U.S. District Judge Mark T. Pittman ruled that the Minority Business Development Agency's presumption that businesses owned by blacks, Latinos, and other minorities are disadvantaged violated the Constitution's guarantee of equal protection. He permanently enjoined the agency's business centers, which have assisted minority-owned businesses in accessing capital and government contracts, from extending services based on an applicant's race. Quote, if courts mean what they say when they ascribe supreme importance to constitutional rights, the federal government may not flagrantly violate such rights with impunity. The MBDA has done so for years. Time's up, wrote Pittman, who was appointed to the bench by President Donald Trump in 2019. This decision marks the latest blow to government affirmative action programs in the wake of the Supreme Court's landmark rulings against Harvard and the University of North Carolina last June. The High Court's finding upended race-conscious college admissions and sparked a broad legal offensive against affirmative action and diversity, equity, and inclusion programs in the private and public sectors. Within weeks, a federal judge in Tennessee struck down a provision of the Small Business Administration's business development program that equated race with social disadvantage as unconstitutional, forcing the agency to overhaul it. Legal experts said Tuesday's ruling could have even more profound implications for how the government provides aid to historically disadvantaged groups. Quote, if this holding withstands appeal, it would immediately disqualify any federal program that operates on a presumption that people of color are socially disadvantaged, said Noah Feldman, a constitutional scholar at Harvard Law School. He added that, were the case to withstand appeal, it would be part of an unsurprising trend. In the aftermath of the Harvard-UNC case, in which the conservative-leaning courts are chipping away at and sometimes actually removing the foundational stones of remediation-based affirmative action. And obviously that's where the momentum is. It's over for these discriminatory programs. Dan Lennington, an attorney with the Wisconsin Institute for Law and Liberty, representing the plaintiffs in this case, called the ruling a historic victory for equality in America. Quote, no longer can a federal agency cater only to certain races, he said. MBDA is now open to all. Justice Department lawyers representing the MBDA did not respond to a request for comment Wednesday because they know they lost and there's really nothing they can do. Neither did the Commerce Department, which runs the agency. Unless they appeal, the agency will be forced to immediately cease using an applicant's race or ethnicity in determining eligibility for the program, according to Pittman's order. Lennington expects the case to be appealed to the U.S. Court of Appeals for the Fifth Circuit, which has a conservative majority, so this is not getting overturned by the Fifth Circuit. He estimated that the presumption of disadvantage is used by dozens of other agencies in many programs worth billions of dollars, making the ruling a likely focus of further judicial review. Pittman has emerged as a consistent conservative voice on a range of politically volatile issues. In November 2022, he struck down Biden's student loan forgiveness program. Months later, he set aside a Texas law barring adults younger than 21 from carrying handguns after concluding that age restrictions violated the Second Amendment right to bear arms. In the MBDA case, Pittman blasted the agency's use of broad racial categories to assist businesses owned by people of color. He said the agency places extra barriers on white business owners, a dynamic he likened to discrimination faced by Irish people in the 19th century and black people during the Jim Crow era. It is exactly the same. Ultimately, he found the MBDA's use of racial categories did not survive strict scrutiny, a rigorous legal test courts use to determine whether government's race-based affirmative action programs are constitutional, dismissing government evidence that minority businesses have far less access to credit than their white counterparts. Even if true, he asserted, it would not justify the government offering services to some races and not others. You can't have a federal government or even a state government or local government offering services, assistance, resources to certain races and not other races. You can't do that. And now it's official by a federal court judgment. Moreover, Pittman wrote, the agency's use of racial categories is imprecise and unfairly stereotypes certain races as being disadvantaged. Under the law, Oprah Winfrey is presumptively disadvantaged, while plaintiffs and even more disadvantaged Americans are not, Pittman wrote. While illogical, this wouldn't be a problem if the presumption wasn't based on race. The opinion cited the Supreme Court's Harvard-UNC decision more than 30 times, a sign that the ruling's influence is extending beyond academia. Though the Harvard lawsuit concerned college admissions, nothing in the decision indicates the court's holding should be constrained to that context, Pittman wrote. Feldman, the Harvard professor, said Tuesday's ruling followed the logical style and the music of the Harvard-UNC decision in applying an extremely rigorous set of strict scrutiny standards that are overwhelmingly difficult to overcome in the real world. Devon Westhill, president and general counsel at the Center for Equal Opportunity, a conservative think tank, said that cases like this represent the next battlefield when it comes to federal programs that make decisions based on race. He expects that the MBDA ruling, taken in tandem with the recent SB 8 Section A decision, will accelerate a shift away from explicit references to race to qualify for certain federal programs and doing away with the government's presumption of disadvantage. But we should probably see a whole host of other federal programs beginning to make that shift that the 8 Section A program did, Westhill said. But he noted that such adaptation could be challenging for a government agency whose explicit purpose is to foster minority business development. Quote, certainly there's nothing wrong with helping minorities in a broad sense, Westhill said. But if you're targeting some people for help and disadvantaging other people because of their race, that is always going to be against the law. On Wednesday, congressional Democrats, affirmative action proponents, and minority business advocates condemned the decision, saying it would harm minority businesses and the overall economy. Quote, to say that I am disappointed in the Texas court decision regarding MBDA programs would be a grave understatement, said Senator Ben Cardin, who led efforts to make the MBDA permanent in 2021. Along with constitutional experts, I am still reviewing the finer details of the court decision. But what I do know is that MBDA programs to support minority communities throughout rural, urban, and suburban America must continue. Yeah, they can continue. They just can't exclude people from participating in those programs and offering those services to United States citizens based on their skin color. You can't discriminate anymore. That's literally the only change. But we cannot allow this court ruling to reverse this progress, he added. I will continue to fight to preserve programs that address historic discrimination and uplift our minority communities. Yeah, the programs continue. The discrimination stops. The MBDA was established by executive order in 1969 by President Richard Nixon and made permanent in 2021 under the Infrastructure Investment and Jobs Act, which greatly increased its funding to $550 million over 5 years. It runs more than 36 centers across the country that help minority-owned businesses secure financing and navigate the federal contracting process. And now it's open to people of all skin colors. In fiscal 2022, MBDA clients secured $1.6 billion in private and government contracts, the agency data shows. The agency also helped businesses raise $1.2 billion in capital, as well as create or retain roughly 16,000 jobs. Black-owned businesses received $680 million in contracts, the most of any group, followed by Hispanic-owned businesses at $526 million. So now it's great. Everyone can get contracts. It won't just be limited to certain people of certain races or ethnicities. Representative Judy Chu, chair of the Congressional Asian Pacific American Caucus, also condemned the decision as the next step in the far-right strategy of using the judicial system to terminate federal efforts that strengthen opportunities for people of color and underserved communities to achieve their American dreams. Alfonso David, a civil rights lawyer and chief executive of the Global Black Economic Forum, said he disagrees with the court's choice to enjoin the remedy to correct historical discrimination faced by marginalized communities. Like Chief Justice Roberts on the Supreme Court said about discrimination, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. No excuses, stop the nonsense. Alfonso David went on to say, these communities continue to confront blatant bias and discrimination in contracting. Davis also cautioned against any efforts to interpret the decision about a single federal agency as being broadly applicable to all federal programs that consider race or voluntary private programs. Oh, Davis is worried because yes, of course this applies to literally every federal agency and literally every federal program. It's getting wiped out of all federal agencies quite quickly, and voluntary private programs that try to discriminate this way are also going to be wiped out. But right-wing advocates will attempt to paint this decision with a broad brush to suggest it prohibits any public or private program that seeks to remedy past discrimination. It does not. Oh, yes, it does. From the Washington Post, SBA program upended in the wake of Supreme Court affirmative action ruling. A judge struck down a provision of a federal program meant to help minority-owned businesses exclusively. Whites need not apply. A ruling that could help imperil other programs that benefit underrepresented groups. And this ruling took place before this ruling took place. Federal judge orders minority business agency open to all races. So the momentum is clearly going in the right direction. Thousands of Black, Latino, and other minority business owners are scrambling to prove that their race puts them at a social disadvantage after a federal judge declared a key provision of a popular Small Business Administration program unconstitutional, extending the U.S. Supreme Court's recent retreat from affirmative action. The SBA 8 Section A business development program was meant to open a pipeline to billions in government contracting dollars for historically disadvantaged groups. But in July, a federal judge in Tennessee struck down a provision of the program that equated race with social disadvantage. So literally, whites are not able to apply for billions of dollars worth of government contracts while this section is in place. If that doesn't seem wrong, well, it is wrong, and that's why it got overturned. The decision, one of the first to affect the private sector in the wake of the Supreme Court's June decision upending race-conscious college admissions, throws into disarray an SBA program that has served minority-owned small businesses for about 5 decades. 50 years of discrimination. Legal experts said it could signal trouble for other programs meant to help underrepresented groups win federal contracts, including veterans and women. This author is talking about disadvantaging veterans and women. Usually when authors in articles want to support DEI programs, they talk about how it negatively affects disabled people. That's the hot new thing they like to do. This article was written a few months ago. He's on veterans and women being disadvantaged, but in his newer articles, he most likely will add in what they love to add in, how disabled people are no longer going to have access to programs, which is absolutely ridiculous. Of course, they'll have access to programs. It's just that skin color and gender are not actually disabilities, and federal law shouldn't treat skin color, gender, or certain religious or sexual preferences as disabilities because they're not. Under the new guidelines, being Black, Hispanic, Asian, or Native American is no longer enough to automatically qualify as socially disadvantaged, a key step in making it into the program. Instead, in a mass email distributed on August 22nd by SBA officials, business owners were instructed to submit an essay demonstrating that race had hindered their success. The revision sparked a full-blown panic from many small business owners who'd benefited from the social disadvantage presumption, said Nicole Potroff, a government contracts lawyer who for years has helped businesses apply for the program. Quote, I had a lot of initial calls from clients, from blog readers, from contractors across the board asking, what does this mean, she said, adding that she's seen a massive influx of business needing help with crafting the essays. Approximately 4,800 businesses participate in the 8 Section A program, and nearly 4,000 of them were certified under the presumption of social disadvantage, according to the SBA. In 2020, 8 Section A firms were awarded $34 billion in government contracts, according to a Congressional Research Service report. $34 billion in contracts, and that's just 1 year. Quote, the SBA is proud of our work to promote equity and level the playing field in federal procurement to attract a diverse supplier base and ensure competition, innovation, and performance, SBA Administrator Isabella Guzman said in a statement. adding that the agency is working with the Justice Department to determine its next steps. Why the Justice Department? Because they have a civil rights division and they can help sue on their behalf to continue as much discrimination as possible as quickly as possible. In the meantime, additional SBA staff are being trained to review the narratives, according to the agency, which is working with the Justice Department to create additional guidance for businesses and the agencies they work with. Michael Rossman, general counsel for the Center of Individual Rights, a conservative public interest law firm that sued the SBA on behalf of a white business owner, Celeste Bennett. Celeste Bennett praised the court ruling. In a statement, Rossman said that we and our client are pleased that we were able to achieve a significant goal of litigation, eliminating the explicit use of race in determining who is entitled to participate in a very advantageous federal contracting set-aside program. And if you think that sounds like they literally took contracts, put them to the side and said, no, you have to be a certain race to get access to these contracts, that is literally what they did. They set aside the contracts to make them only available to certain people of certain races. And now that's being stopped. That's how significant this is. In 1 year, $34 billion worth of contracts. The upending of the 8 Section A program marks one of the first casualties in the business world of the Supreme Court's landmark decision holding that race-conscious admissions programs at Harvard and the University of North Carolina violate the Constitution's guarantee of equal protection. The 8 Section A program's reliance on the presumption of social disadvantage was similarly unconstitutional. District Judge Clifton Corker wrote in his July 19th order enjoining the SBA from using the presumption. Corker, who was appointed by former President Donald Trump, referred to the Harvard case 9 times in what observers call one of the first interpretations of the Supreme Court's affirmative action ruling. Quote, the facts in the Harvard case concern college admissions programs, but its reasoning is not limited to just those programs, Corker wrote in a footnote. The SBA changes come amid a broad legal assault on diversity, equity, and inclusion initiatives in the private sector, one that has only intensified in the wake of the Harvard and UNC decisions. Edward Blum, the conservative activist behind the 2 college admissions cases, has several pending lawsuits targeting private sector DEI programs. And in July, more than a dozen Republican attorneys general fired off letters warning the nation's largest companies that explicit racial quotas and preferences in hiring and promotions would invite legal action. That a judge struck down the SBA's use of the presumption of social disadvantage, quote, wasn't completely surprising to us because we've known that there's been a number of cases that have been brought and funded by conservative legal foundations that have always questioned any affirmative action, said Antonio Franco, managing partner at Piero Mazza, based in Washington, which works with government contractors to apply for the 8 Section A program. After the Harvard rulings, Franco said he remembered thinking it was only a matter of time before the same kind of ruling comes out with regard to the 8 Section A program. Other government business programs meant to benefit disadvantaged groups may also be vulnerable, Franco added. He cited the Transportation Department's Disadvantaged Business Enterprise Program, which dispenses transportation-related construction contracts to minority-owned businesses. Though different from the 8 Section A program in some respects, it relies on the same social disadvantage presumption. Patroff said the Harvard rulings have essentially made no SBA program safe from scrutiny and legal challenges, including the service-disabled veteran-owned small business program, women-only small business program, the small disadvantaged business program, and the historically underutilized business zones program. All of those certifications are key in helping disadvantaged business owners win contracts through the federal government. She goes on to say, I am very concerned that the 8 Section A program itself is going to be on the chopping block at some point, and I think that is why SBA is swiftly implementing things and trying to appease the courts, because they don't want the entire program to be on the chopping block. To qualify for the 8 Section A program, a small business must meet several requirements, including being 51% owned by U.S. citizens who are socially and economically disadvantaged. Social disadvantage is defined as a racial prejudice or cultural bias within American society stemming from circumstances beyond an individual's control, and people of certain races and ethnicities were automatically assumed to be socially disadvantaged without further proof. Those who did not benefit from the presumption of social disadvantage were required to write a narrative citing specific instances in which an objective distinguishing feature negatively impacted a business owner's advancement in the business world, and that disadvantage must be chronic and substantial, according to Patroff. Often, business owners who applied to 8 Section A through the narrative did so on the basis of their gender, sexual orientation, or disability, she said, and they were often extensive and detailed documents. Though they had a high success rate, Patroff said, Crafting narratives requires the help of lawyers and imposes a substantial financial burden. Of course, those lawyers are not working for free, and that's the substantial financial burden. The ruling against the 8 Section A program came in a lawsuit filed in March 2020 by Ultima Services Corp., an administrative and technical support business. Ultima's owner, Celeste Bennett, claimed she was being prejudiced from being awarded a contract under the 8 Section A program because she's white. Filed against both the U.S. Department of Agriculture and the SBA, the lawsuit claimed that Ultima lost out on USDA contracts that went instead to businesses participating in the 8 Section A program. Because Bennett did not benefit from the presumption of social disadvantage, she argues the program discriminated against her. The lawsuit argues that 8 Section A's so-called rebuttable presumption of social disadvantage, the presumption that Black, Hispanic, Native American, and Asian people are in all cases socially disadvantaged, violates the Fifth Amendment, which covers due process rights, but also incorporates the 14th Amendment's Equal Protection Clause when applied to the federal government, according to Corker's order. In his decision, Corker wrote that the SBA and the USDA failed to establish a compelling interest in their use of the presumption, meaning they did not provide enough evidence that it was needed to remedy the effects of past discrimination. Moreover, Corker wrote that the presumption's reliance on broad racial categories was not narrowly tailored to address past discrimination. The judge cited the Harvard case in reaching both decisions. In a March 2022 deposition, Bennett said she had never applied to the 8 Section A program. When asked why, she responded, "Because I'm white, and I knew I would never be accepted into the program." Bennett said she started her business Lusa in Maryland with $5,000 and acquired Ultima in 2002 with $20,000 that she borrowed from her father, who also owned a government contracting business. Bennett added she later borrowed approximately $500,000 from her father's company after being denied loans at several banks over the course of about 5 years. In 2019, court documents show Lusa was awarded 2 contracts from the Natural Resources Conservation Service worth $3.8 million through a women-owned small business program. Asked during the deposition why she chose to take advantage of the program for women but wanted to challenge a similar program for minorities, Bennett replied, quote, "Because I don't set the rules, and I need to play. You can't have special programs that give advantages and give exclusive contracts funded by the federal government to only certain races or certain genders. It's not appropriate. And what's going to happen to all these programs? Over time, they're going to get removed because they're not constitutional. And that's better for all Americans." Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.